State consent is the centerpiece of international arbitration, as well as any kind of dispute settlement in international law. In order to be able to bring a claim against a state, a foreign investor must be in a dispute settlement relationship with the state hosting its investment. This means that this host state must have made a standing offer to arbitrate, which the investor can act on in order to bring this dispute. This standing offer to arbitrate can be made either through an investment contract or through, as it happens most often, through an international investment treaty. Now, states can tailor and do tailor in their investment treaties the terms of their standing offer to arbitrate. They do so on the basis of their own policy objectives. They may, for instance, limit the scope of their standing offer ratione personae. This means they may exclude certain investors from the possibility of bringing a complaint. There are clauses which are called denial of benefits clauses, which states include in their investment treaties in order to prevent foreign corporations which are owned entirely by persons of the same nationality of the state to bring a dispute. States may also limit the terms of their standing offer ratione personae. They may limit the norms or the rules on the basis of which investors can bring a claim. For instance, in its earlier bilateral investment treaties, China limited the possibility of international dispute settlement only to the calculation of the quantum of compensation after expropriation. Thirdly, states may even accept a certain form or more than a certain form of international arbitration. States may include both interstate and investor-state dispute settlement. For instance, in its bilateral investment treaties, Cuba includes only interstate dispute settlement. States may also include ICSID or UNCITRAL ad hoc arbitration, or even both. However, most often, states include in their standing offer a certain number of procedural requirements, which the investor must satisfy in order to be able to bring this claim. These procedural requirements are usually included in the so-called compromissory clauses of investment treaties and are worded in mandatory terms. The most used procedural requirements are the so-called negotiation periods or cooling off periods, which are usually of between 6 months and 1 year. Local litigation requirements, whereby before going to international arbitration, investors must first seek redress in national courts, or even a requirement for the exhaustion of local remedies, just like in customary international law. Now, I said that the requirements are worded in mandatory terms. However, international arbitral jurisprudence is divided on the point of interpreting these procedural requirements. There is no jurisprudence constant. The question here is what happens in the situation in which an investor does not wait for 6 or 12 months as required by the treaty, or does not first litigate before national courts. In these cases, if the investor fails to obey to procedural requirements before it brings an investment claim, should the relevant arbitral tribunal decline the exercise of jurisdiction? In other words, are we speaking about a provision which goes to the heart of the jurisdiction of international tribunals? Or are we speaking about matters of admissibility over which investment tribunals can exercise a certain degree of discretion. On this point, there are at least 3 lines of jurisprudence. The first is represented by the Nafta arbitral decision in Untitled Corporation versus Canada. This case concerned the prohibition of MMT, a fuel additive which was considered by the Canadian government to be dangerous for the environment. Untitled Corporation, an American company, had tried to negotiate or at least to lobby with the Canadian government but had failed to do so. It had brought a claim under international arbitration as soon as the ban was approved, without waiting for the 6 months required by Article 1120 of Nafta. So the question before the tribunal was whether it should continue hearing the claim, even though Untitled Corp had not respected the procedural terms laid down in Nafta. So the tribunal answered that this procedural requirement did not affect its jurisdiction. It did so on the basis of 3 motivations, 3 steps. Firstly, it looked at the object and purpose of Article 1120 of Nafta. It said that the object and purpose of this provision is to allow for states the possibility to settle fairly and, let's say, peacefully the dispute with the investor. In other words, the object and purpose of the clause is to give an opportunity to the parties to solve the dispute without having to litigate. Secondly, it found that in the situations of the case, the behavior of Canada had rendered completely futile any eventual attempt to negotiate under this negotiation period rule. Thirdly, it made a parallel with the customary international legal rule of the exhaustion of local remedies. As you know, under the customary international law, before a state can espouse an international claim, the rule of exhaustion of local remedies requires the investor, the national of the state, to have used all possible means offered by the national law of the host state. However, the rule on exhaustion of local remedies has an exception where pursuing domestic remedies would have been futile. So, the tribunal makes a parallel with the customary norm on the exhaustion of local remedies in order to derive from these procedural requirements a futility rule. The investor doesn't have to respect this negotiation period, and the investment tribunal may exercise jurisdiction where the pursuance of negotiations, the respect of this waiting period, would have been completely futile. This decision became very popular. It has been followed by a variety of successive arbitral tribunals, such as, for example, the arbitral tribunal in Arts Finance versus Slovakia, or the arbitral tribunal in SGS versus Pakistan. However, despite its popularity and its value as a precedent, this decision is problematic for 2 reasons. The first is that it ignores the mandatory language of the provision. According to the plain wording of Article 1120 of Nafta, the parties shall wait 6 months before submitting a dispute. And the second problem is the one of the interpretation of the futility exception on the rule of the exhaustion of local remedies. The Tribunal of Untitled Corp takes for granted that the futility exception would be applicable where a favorable outcome for the investor is unlikely. However, this is not exactly the meaning, the real meaning, of the rule of exhaustion of local remedies. The rule of exhaustion of local remedies will uphold this futility exception where the solution of the case under domestic law is legally impossible and not where it is unlikely. This has been confirmed by a successive Nafta case, which is Apotex versus USA. A second line of jurisprudence that is related but not exactly the same of Ethic Corporation versus Canada is the one of Arbitral versus Argentina, which was decided by an ICSID tribunal under the BIT between Argentina and Italy. Arbitral concerned the purchase by approximately 60,000 Italian investors of sovereign bonds of the Argentine Republic. The Italian investors had acquired these bonds through distribution, through sales made by Italian banks. They were secondary purchasers. And the Argentinian economic crisis forced Argentina in 2002 to default on its debt and ask the renegotiation of the assets held by Italian investors. The BIT between Argentina and Italy conditioned the consent of Argentina to international arbitration on a requirement of domestic litigation. The investor, in this case Abacrat, must have first litigated for at least 18 months before Argentinian courts. However, the investor had not waited this time period and had directly gone before international arbitration. The question again is the same. Should the tribunal uphold or decline jurisdiction? So here, too, the tribunal started from the object and purpose of the procedural requirements in the BIT. They stated that the object and purpose of these requirements is to give the state a fair chance to address the complaints of the investor. So for the tribunal here, the real question to ask in such a contentious issue is, has the host state been deprived of a fair chance to address the issues with the investor? This implies a balancing exercise between the state's interest to see the dispute settled in its own national system and the investor's right to legal redress. The tribunal made a consideration of the factual circumstances, found that litigation before Argentinian courts would have been futile, and decided that the investor's right to legal remedy was more important or trumped the state's interest to see the dispute settled. And so, having done this balancing exercise, it found that it had jurisdiction to hear the dispute. The decision was attacked by one of the members of the arbitral tribunal, who attached a very strong dissenting opinion. According to Professor Abisab, there are two major issues with this majority decision. The first is that this balancing exercise is nowhere to be found in the wording of the treaty. According to him, the tribunal just invented a legal test which was not supported by anything within the BIT. The second issue is that the tribunal majority used the language of fairness, thus so settling the dispute ex equo et bono without the consent of the parties. Another criticism that is independent from the one of the Professor Abisab is that the tribunal ignored the jurisprudence of the ICJ when interpreting similar compromissory clauses. This was precisely one of the criticisms made by the third and last line of jurisprudence on this question, which is represented by the case of Tulip Corp versus Turkey, decided by an exit tribunal under the BIT between Netherlands and Turkey. So this case concerned a housing project a series of housing projects in Ankara and Istanbul. And one of the questions that arose was the jurisdictional nature of the 1-year negotiation requirement within the BIT. Here, the tribunal started from the mandatory language of the BIT and referred to the jurisprudence of the ICJ, which in the case of armed activities in the Republic of Congo, DRC versus Rwanda, had found that every single condition attached by a state to its consent to arbitration constitutes a binding limit on the jurisdiction of an international tribunal, which made procedural requirements in international conventions a question of jurisdiction. Thus, here, the tribunal in Tulip Corp versus Turkey explicitly contradicted the jurisprudence, the two case laws that I have quoted before. So you can see that the construction and interpretation of compromissory clauses in international investment law is and remains an extremely controversial topic, despite the apparent simplicity of those provisions. This is, of course, just a summary and a very short introduction. If you want to find out more, I invite you to read the relevant section on Canvas. Thank you for your attention.